Hello, everyone. Kia ora. I'm really delighted to be here today to talk to you about this important area, and we'll be busting some privacy myths around DNA. This draws upon my past and ongoing research around this industry, and I've also framed this so it's pitched for an introductory audience, but I'm trying to cater to everyone. But I will start by very much by introducing the industry, and we're going to deal with some of the problems it raises for privacy, but also think about this in the context of data breaches and the way that people engage with privacy policies and online contracts. So this industry, direct-to-consumer genetic testing, which is also known as DTC or personal genomics, sometimes even commercial genomics or recreational genomics. But it's basically the industry that has created a market for DNA tests as consumer services. It's something that operates internationally, which also causes problems in terms of how we approach regulating it. And it does mean too that when you're a consumer engaging with one of these companies, you may often be located in a different country from where the company actually operates. And this may mean that your DNA sample is processed and stored overseas, which does have an impact on the ability of New Zealand-based regulators and other regulators in other countries to actually enforce existing legislation on this industry. So there's a few things I'd also just like to highlight here. I'm not going to dwell on these, and I will make these slides available after the event. I'm very happy to take questions. I'm going to talk for about 40 minutes and then take questions, but if you have any other questions, feel free to contact me. And the links to all these articles are included in the slides, but this is just to give you a little bit of background in terms of the idea that data breaches are occurring. They're occurring on a wide scale. They're increasing in the number of people that they impact, and they also are affecting all industries, but particularly the healthcare sector is prone and vulnerable to these attacks. And one that I'm particularly going to highlight today is the 23andMe breach. But you'll see that even overnight, there was another breach in Australia. We've experienced several large-scale data breaches in New Zealand and Australia in the last few years. And we've also seen ones such as the wearable tech breach, which affected 60 million wearable devices, which occurred in 2021. So this is happening on an international scale. It's affecting people and their families. And it does mean that we really need to be careful who we give our data to in this online environment. Oh, oops, I clicked something wrong there. Okay, just wait a second. Right, so the data breach that I'm going to highlight today, and I'll come back to this later, is the 23andMe data breach. This occurred last year. 23andMe has approximately 14 million customers in their database. This breach has impacted almost half of them, around 7 million people, and it was enabled through something called credential stuffing initially. And this is the process whereby a company lets a user create an account by linking it to an existing account from another large platform such as Google or Apple. Attackers were able to access over 14,000 accounts using this method, which meant that they had access to the user's username and password, and that's how they first breached the security of 23andMe. So to begin with, though, how does this work? For those of you, some of you may be familiar with it, some of you may have had a test or know people who've had a test, but for others of you, I really just want to give a brief introduction so everyone's on the same page. So these tests are offered through website platforms, and a customer will normally buy the test, they'll pay for it and order it, and then be sent a test kit. Now, the test kit is for the purposes of taking a DNA sample. This normally involves people either spitting into a tube for a saliva sample or taking a cheek swab. Now, they then send the sample through the mail old-fashioned in some ways, back to the company, which may be based overseas. And the company then will process that sample and sequence that person's DNA. Now, this means that their genetic information is generated in a digital form. That information can potentially be stored indefinitely, and it's something that can serve as a unique identifier for that person, as it's not going to change over time in a way that would mean we couldn't link it back to that individual. Also, because we share a lot of information with our families, this does pose privacy risks for individuals' families. And your genetic information is not the only information these companies are interested in. They tend to collect other types of personal data through their websites, often through surveys, but also particularly for ancestry testing services, there's a lot of social networking features. And I'm going to show you a few screenshots soon just to show you the wide range of services out there and the real problems that these raise. So the next point I wanted just to highlight, though, is that this industry is diverse, and that's why I'll show you quite a range of shots today and talk about different issues to do with different types of testing. But really, the companies that are most well known are generally at the better end of the spectrum. I still have concerns about the industry as a whole, but companies such as 23andMe, even though we've mentioned the data breach and Ancestry DNA and MyHeritage, they're all quite prominent. A lot has been written about them, and that more attention has been paid to their services. At the other end of the spectrum, we have very dubious types of testing, which I'm going to get into in a minute. And the problem with that is that the industry as a whole has really not got a lot of oversight. So if you're interested in having one of these tests, I strongly encourage you to discuss it with family and friends first. So because this is a myth-busting week, these are some common myths about DNA in this particular context. Now, the first one is that people, if you're interested in having a test, you're probably interested in having a test for a specific reason. You might want to know about your ancestry. You might want to know about particular health risks, but you probably won't anticipate, and a lot of people don't anticipate, the wide potential for sharing of this information. Now, there's been examples of these companies engaging in a lot of medical research. There's been a lot of partnerships between the direct-to-consumer testing industry and pharmaceutical companies. For instance, 23andMe has had at least 15 partnerships with pharmaceutical companies and has since been acquired by Virgin. There's also been engagement with law enforcement and sharing with law enforcement and immigration authorities. So your data may be used in ways you really might not anticipate. And one of the things just to bear in mind here is I've said there's a spectrum at the moment. Most companies don't restrict themselves to offering just one type of test. And the other thing about this is companies are generally not making a profit from the sale of tests themselves. They're actually making a profit through using consumers' data in secondary research and engaging with partnerships and mergers, engaging in partnerships and mergers. The other point to just emphasize here is that we often tend to trust that our data will be secure. And particularly given the sensitive nature of this service, that might be something that you do tend to believe. You might think that the data is going to be secure. Unfortunately, even where companies do their best, though, today, they can't guarantee total data security, and that's a real continuing problem. Another thing is that you might tend to trust the company's privacy practices on the basis of their privacy policy, but have you actually read that privacy policy? Because sometimes privacy policies are just that. They're saying what a company does with your data, but if you haven't read it, it might actually be going to do things with your data that you're not comfortable with. And the last part is that a lot of people might actually believe that the industry is regulated well, and so there's a lot of protection for them in this space. unfortunately, there are significant problems with regulating this industry, and it's been quite poorly regulated to date. Now, I've had 2 funded projects, one which I'm going to mention later, which talks about consumer risks in this space, and I've included a link to an animated video that we've produced, which talks you through some things that you should think about before engaging with this industry. But I've also been part of a project with a colleague, which was funded by the University of Waikato and Genomics Aotearoa. And in that project, we actually did a public survey in Australia and New Zealand, and we'll be sharing findings from that later in the year. But in our survey, we have found that people generally, there is quite a bit of support for people wanting the industry to be regulated. And that's something I've been trying to argue for over the last few years as well. So before we continue, I just want you to keep 2 questions in mind. Now, bearing in mind I'm a legal academic and some of my job has been to read online contracts. So for instance, in my book, I actually reviewed 71 online contracts from companies that marketed DNA tests for health purposes. So I have read my fair share of contracts, but I would just like you to think about these questions. How many contracts and privacy policies do you think you have encountered online? And how many of these do you think you have read? And I can honestly say I couldn't count how many contracts and privacy policies that I have encountered online, and I know that I have not read all of them. And I'm admitting and part of the problem for that, though, relates to not just my or anyone else's level of skill or level of time, but the sheer volume of documents we're encountering online. So I'd just like to highlight the work of the Norwegian Consumer Council. They are a consumer advocacy group in Norway, but they've done a lot of excellent work relating to different types of technologies. And in 2016, they actually did a campaign called At Fail, which was looking at the contracts and privacy policies, well, really contracts of mobile phone users in Norway. And at that time, they estimated that the average smartphone user had 250,000 words of app terms and conditions on their phone. Now, just to give you some perspective, when I wrote my doctoral thesis, that was about 100,000 words and 300 pages. Thinking about this is actually more than twice that in length. And just bearing in mind that this study, which also involved a live app readathon, they read terms and conditions aloud, this was conducted in 2016. So the amount that people are engaging with is likely to have increased significantly, just given the shifts that have occurred since COVID-19. The other thing just to bear in mind here is that even if we choose to read these, we really may have difficulty understanding them, and it will take us a lot of time. This is a sort of fun example from a Guardian journalist from a few years ago, where he spent a week reading 146,000 words of contracts. But this is a really unfortunate reality, because often contracts on websites will refer to their privacy policies and allow people to and companies to change those policies based on the contract. Now, another study from back in 2008 estimated at that time that it would take 201 hours a year for the average American consumer to read all the privacy policies they engage with online. And so just think about that. Think about all the services that have moved online and how our cyber and physical worlds are beginning to merge at the moment. There's so much of this documentation out there that people aren't engaging with, and it's really problematic when we think about sensitive services. So these contracts are everywhere, and in order for an individual to really understand their rights, you would actually have to read these documents. And that's the unfortunate reality that we aren't. And I really think we need significant reform in this space. The other thing just to remember here about your DNA is that you share it with your family. It can potentially be stored indefinitely, And it's been shown that it's possible to re-identify individuals in quite large databases with access to very little information about them. So this means that the risk of a data leak doesn't necessarily decrease over time. Now, moving on to the actual thinking about the industry portion of this talk, many of you may have heard of some of the most prominent companies, so 23andMe, Ancestry DNA, Family Tree DNA, and MyHeritage. Those of you who have an interest in genetics might even be aware of Decode, which originally had the contract to map the genome of the Icelandic population, which was very controversial at the time because they're a very closely related population, and this was done on an automatic opt-out basis. But so you were automatically opted in and you had to opt out. And also they then became a direct-to-consumer testing company as well. There's many other companies out there. I've done a lot of research around this industry and identified more than 200 companies offering some form of DNA test with an English language website in the period that I've been looking at this, which is from about 2011. I've actually released some of my data as well. I hope to release updated data sets in the future, but this is just really to give you an overview. Now, most of you, if you have had a test, or you know someone who's had a test, or you've heard of the industry, you'll probably be aware of ancestry testing and health testing of various types. The thing to be aware of here is that ancestry is by far the most popular type of testing at the moment, and health testing would probably be the second most popular, but both of these types of tests are not standardized. People can get contradictory results from different companies for different health conditions. They can get contradictory estimates relating to their ancestry. And so you really need to be cautious about how you treat this information. But those types of more well-known testing are generally offered by more prominent companies, and there's been more awareness around this and a lot of scholarship written about it. Unfortunately, we have growth in other types of testing, such as child talent or paternity testing, which is often done on a peace of mind basis with no witnesses. So more than 90% of the companies that I have looked at that offer paternity testing offered a cheaper, informal option, and then a legal, court-approved, more expensive option. And I'm going to take questions at the end of this, but I'll just try and keep an eye on this as we go. I'll come back to that question, but I have heard you, so I'll come back. The other tests that you'll see are infidelity, which is often dubbed surreptitious testing, and is by definition non-consensual and very concerning. And there's also been examples of even genetic matchmaking and forensics. The industry is united, unfortunately, though, by the fact that most companies are not offering whole genome sequences at this time or whole exome. So this means that the information that you get, particularly if you're interested in health testing, is inherently limited because they're not looking at your whole genome. Before moving on, I will try and tackle that first question, because the first question is, are there any New Zealand-based companies or universities that do DNA testing for individuals if they're interested in finding out more about their whakapapa? Now, there are some projects that are being conducted in different universities, but there are not many New Zealand-based companies at the moment. And one of the problems here that I would just suggest, if you are interested in this, it might even be something that you want to wait for a little bit longer before you engage. But one of the problems at the moment is some companies that look like they're based here because they have a New Zealand-based domain name don't actually do their testing here. So there's just something to be aware of. And there's a lot of potential for your data still being shared with other entities overseas. So just be cautious there. And I'll try and tackle the other questions coming through soon. But these are some examples of what's out there in terms of health testing. So this is a very recent screenshot. This is the American version of the website. Some of these we only seem to be able to order ancestry tests at the moment, but this is just to give you an idea of what's out there. But we've also got some examples from Amazon Australia where they do have free delivery to New Zealand. Some of these do include health tests. You'll see a few of them are also offering ancestry, and they're offering a combination of tests here. And this is a more expensive genetic predisposition test for a variety of health conditions that is offered by EasyDNA. Now, EasyDNA is an example of a company with a lot of different domain names in different countries, but it's possible that your tests will actually be conducted outside New Zealand. So it's just something to be aware of. The other thing is that there are a lot of limitations for health testing. So with Ancestry, I support people wanting to know more about their heritage, and I'm very interested in my own family history, and I have quite a mixed background, but I still haven't engaged with any of their services, partly because I've been looking at them for more than a decade and I'm just rather a cautious person. But particularly for health testing, you really do need to be more cautious because most health tests are not standardized, and that means that you could be falsely reassured or unnecessarily worried. And in this study from a few years back, they found that the BRCA testing offered by 23andMe, which looks at the BRCA genes which are associated generally with your likelihood of developing breast or ovarian cancer, it misses 90% of the known, it missed 90% of the known mutation carriers at that time. And they recommended that you would need follow-up testing in a clinic, both for positive and negative findings. So if you do have a serious health concern, I seriously recommend talking to your doctor about this before engaging with this, and also just comparing some of these. And I have a list of related publications at the end of these slides. So if anyone does want to read further about this, please do have a look at my work and hopefully it will help you. So the ancestry testing world is something that's really growing. This is a shot from the international version of 23andMe's site. So this is what you could order in New Zealand at the moment. This is some examples of ancestry testing from Ancestry DNA's Australian website, which also ships to New Zealand. And you'll see that the cost of these tests is so much lower, I would have to say too, than if we think about the costs of sequencing the first human genome. So these are very cheap, but that does mean that unfortunately, similarly to some other free services online, where we talk about things like Facebook, where you might be paying for the free service with your data, to some extent you still are in this context, even though you are paying money as well. So it really is quite concerning. And there's a couple of other examples just to give you some insight into the range of tests out there. MyHeritage also had quite a significant data breach in the last few years, which I will mention later. And this is the unhappy reality. So sometimes people might find unknown relatives and it might be a really good, positive experience. I'm actually on the advisory board for a project in the UK, which interviews people who are donor conceived and their families around their engagement with this industry in relation to donor conceived people. But there are unhappy realities that can emerge from this as well. And this is from quite a few years ago, that's now 10 years ago, 2014. That's bizarre, isn't it? But this example had involved an individual whose real name was not George Doe, who gave their parents DNA tests as Christmas gifts. And subsequently, their father was connected with an unknown son, and that led to the demise of their parents' marriage, which was not their intention. And unfortunately, this type of reality is something that can occur. So sometimes I would suggest, if you think there are skeletons in your closet, it's probably better to try and have a calm conversation with family about this before engaging with some of this. Now, I've talked about ancestry and health, and I'm going to come back and talk about some other issues related to the industry broadly, but I just wanted to mention some other examples of lesser known types of testing because they do raise significant privacy issues. So child talent testing is on the rise. It's not well validated scientifically. These companies purport to tell you about your child's abilities and traits based on their DNA, which promotes a very genetically deterministic view of humanity, which is not particularly, which is really problematic. And I'd just like to give you some examples here to show how this tends to prey on people. You'll see in this example, this company is still going, and it says very similar things on their website today, but this is an older screenshot just so I could fit it on the screen. But you'll see it's saying that you'll save money and you can have a better time management. And the underlying ethos of this tends to be something like, if your child is not going to be Mozart, why would you bother paying for music lessons? But this is really problematic because there's even been an example called soccer genomics, which specialized in a connection between genetics and individual soccer playing ability, which is very, well, it's another example that really isn't well validated and generated some genuine scientific backlash. A lot of the research around genetic traits that are linked to sporting ability, the main ones being to do with whether you're likely to be good at long distance running or good at sprinting, tend to have been shown not to have a determinative effect, and some elite athletes don't possess those variants. So this is really something that I'm very concerned about because we don't know where this data is going to end up. So there's something I would really be cautious about sending a child's data to one of these companies, because we don't know how long it will be stored for, what it will be used for, how it might impact a child's prospects in their future. And there's just one more example there. And in terms of showing you the range out there, this is something that you won't see as commonly talked about in the literature, but it's something that is a reality. It's something that I really strongly would discourage people from engaging with. It's not well validated. It encourages people to send in samples from other people without their consent, and samples of very, very dubious quality. But I wanted to show you that it's happening in Aotearoa, New Zealand. And just as one example here from EasyDNA, and another example from IBD, IBDNA, International Biosciences, I think is the full name of the company. And this is something that really plays into problematic power relationships and can potentially lead on to domestic violence or other things. It's something that really, even if you were genuinely concerned that your partner was cheating, this is not the way to go about it, because this is sending unidentified samples that might even be from your partner to a website where you really don't know where that data is going to go. So this is something that really needs to be cracked down on. It's illegal, or it should be illegal here, and it's definitely illegal in a lot of places, but these companies seem to be getting around the law at the moment. So coming back to privacy in this space, the industry as a whole raises a lot of privacy issues because of the nature of genetic information. And it does mean that if you've shared with a lot of people, and I mean, even if you meet people through one of these platforms and you find it a rewarding experience, there are still going to be examples where people could actually be defrauded in this context, or may share with people who might have malicious intentions. So if you share a lot of information, then decide to delete your account, it may actually be problematic and difficult for a company to actually ensure that all of that data has been deleted and not accessed by other parties with whom you've already shared. Also, if your data has been used in health research that's already begun prior to you withdrawing your consent or wanting to delete your account, it's likely that that data will continue to be used. The other thing just to bear in mind, I've said this is a unique identifier, but it's something that's come up in a lot of the literature and a lot of talk around this, and it's a very important point. We can't change our stored DNA in the same way that we could change our bank password if something goes wrong. Once it's there, it's potentially there forever, and it can affect not just us and our immediate family, but also our descendants. So it's something just to think about before you engage with it. And coming back to this idea of data breaches and data security, is your data totally secure? Well, my answer is probably not at this point. We've seen a few examples already of data breaches on quite significant scales. This is one example from DNA Diagnostics from 2021. MyHeritage had a breach that affected more than 92 million users. Fortunately, at that time, it seems that it was not possible to access genetic information from this breach. But in the 23andMe breach, genetic information, people's birthdays and home addresses and profile photos have been accessible. And also it's emerged that there has been an attempt to sell information on customers with Chinese heritage to the Chinese government on the dark web, and there's been a few other examples where the hackers were targeting people who had Chinese or Ashkenazi Jewish heritage, which is really problematic. And it really is very worrying that 23andMe had so many of its customers affected. They now face 38 class actions have been filed in the USA, and at least one class action has been filed in the Canadian province of British Columbia. So we'll see what happens out of these class actions. I'm hoping we might see something positive. And the other thing just to bear in mind is I've said that your data can be shared and can be used for health research. It can be used for a wide variety of different types of research. Law enforcement are beginning to start wanting to use this as evidence in court. There's also been examples of immigration authorities trying to use this to identify someone's national origins in order to deport them, which is a very problematic use, because just because you have heritage from a particular country doesn't necessarily relate at all to whether you're a citizen of that country. And as you'll see, most famously, there's been interest in this in cold cases. And the Golden State Killer has been the most prominent example of this. This originally involved GEDmatch, which is a genetic genealogy website, and it doesn't actually sell tests, but it allows people to upload data from other sites. But I'd like to end, I'm going to end in a couple of minutes, but there's just one example I'd like to touch upon just in relation to using this in a law enforcement context. And I very much support the recommendations of our Law Commission previously in their report in the last few years, which I also made contributions to. But in thinking about how we use DNA in a criminal context, we do need to establish governance mechanisms and have a public debate about how this is used, particularly in the context of these commercial services. Because if you think about it, particularly when we're dealing with a company based outside New Zealand, it's very difficult to control what's done with a person's data or a group's data once it's outside New Zealand. And this example is from a few years back. You can access the article from Wired. It's a very good introduction to this area. But it talks about the case of Lucas Anderson. He was on trial for murder in America. He had confessed because he was prone to blackouts and he thought he might have done it. But the only piece of evidence linking him to the crime was traces of his DNA underneath the fingernails of the murder victim. And when I talk to my students about this, yes, this does seem pretty incriminating, and often that might be incriminating. But the problem is today, I'm not touching you. I'm not giving you any of my DNA. But if we were in the same room, we could all leave traces of ourselves in that room that have nothing to do with us committing a crime. And Lewis was very, very lucky that he had a good lawyer who happened to look into the details of his case. And they found that on the night in question, he was so drunk because he was homeless as well and an alcoholic. He was so drunk he became unconscious, and paramedics were called to take him to hospital. And later that night, the same paramedics attended the murder scene and somehow transferred his DNA to the body of the murder victim, because Lucas was in hospital all night, and the hospital had clear records of that. Now, this just highlights how badly things can go wrong, because the other problem that we have today is that although I've studied some genetics as part of my doctorate to understand this industry better, and I have an interest in learning about it, not all of us will study genetics in an advanced way at school, and often people are getting a lot of information about how DNA might be used in criminal investigations from television shows. And this is often depicted as some sort of magic bullet, but it really isn't all the time. And the phenomenon of DNA transfer, which is basically that idea of leaving traces of ourselves and how bits of our DNA can transfer to other objects, is a very underfunded area of research that we need more work to be done on. Now, coming back to the reality of how this is regulated. So at the moment, privacy law, data protection law, consumer protection law should be applicable to this industry. But the reality is that companies have been using their online contracts and privacy policies to govern their relationships with consumers. And this comes back to that problem of the volume of documents we encounter. So for example, on some versions of some of these websites, you might encounter up to 11 legal documents. And it's very likely that a lot of consumers are simply not engaging with these. The other problem here is that often these contracts actually contain things that could be challenged on the basis of unfairness. Now, we have legislative control. We have legislation controlling unfair terms in New Zealand. It's very similar to the legislation in Australia, the UK, and the EU. So similar arguments could be made about some of these terms. And often these contracts actually link to privacy policies and allow for significant changes to how your data is used. Now, I'm almost finished, and then I'll address more questions, but just a couple of things that you might want to read if you're interested in this area and you haven't really delved into it before. So this is a conversation piece written by my colleague Samuel Betcher and another colleague of his, drawing upon their study, which looked at the readability of the 500 most popular US website terms and conditions. And they found that more than 90% of those are written at the level of an academic journal article. Now, I'm an academic. I have several law degrees. There are some articles that I've read in law journals that I would still struggle to understand at times. And most of us will find it difficult to engage with very complex, very complexly written legal contracts. And just to give you a few examples, these are fun examples of experiments where companies or other entities have inserted problematic clauses into their contracts to see if consumers were paying attention. This is a very famous example from GameStation, which is a video game retailer in the UK. They inserted this immortal soul clause, and if you opted out of the clause, there was a tick box, you would have got a £5 voucher, but more than 80% of people just accepted the clause. And then this is an even kind of worse example from Purple Wi-Fi. There's been a lot of public Wi-Fi experiments that have done this sort of thing. But Purple Wi-Fi inserted a community service clause where they got over 22,000 people to agree to 1,000 hours of community service, which included things like hugging strangers and cleaning public toilets and painting snail shells. So these are not enforceable, obviously, but these are very problematic clauses which demonstrate just the scale of what might be buried in these documents. And at the moment, based on the reviews I've previously conducted looking at these contracts, I can say it's very common for companies to include a clause that gives them broad power to alter their terms, often without notice. They'll often disclaim liability for fitness for purpose of their tests or anything on their website. They'll often want to bind the consumer to resolve any legal disputes in another jurisdiction. So that means it might limit your ability to sue them in New Zealand. They'll also want you to indemnify the company. That's quite common, which means you have to financially back them. There's an example of an unfair term, but it's very common. And there's very broad intellectual property licenses, which claim the ability to use an awful lot of the content that you post on the site. At the moment, some of the ones I've seen, because I've just written a recent paper, which is forthcoming about this, they often specifically exclude owning your genetic data, but there have been examples where in some versions of the contracts they have tried to say that they own a user's genetic sample. And consent clauses are also quite problematic. And so just to wrap up, there's a lot of concern about this. The Norwegian Consumer Council actually reported MyHeritage on the basis of its terms and conditions, and their data protection authority started an investigation into them in 2021. And then this is our video project, well, our project on fairness and transparency in emerging health markets. This is a joint project with Professor Samuel Betcher, who's based at the University of Victoria in Wellington. And we're really grateful to the Boren Foundation for supporting this. But if you are interested in this, and particularly if you haven't really engaged with the industry before, please do watch our video, because it just talks you through some things to think about if you're considering purchasing a test. And we also wrote a conversation piece and a few other, we've done another op-ed and another chapter that you might find helpful. I'm not going to read this out, but it's just things that you should consider. And these are some suggestions for reform as well. But I'm going to stop talking and I'll leave you on this slide at the moment with some links to things so you can take a shot of it if you want to read any of this. And I'll try and address some more questions now. So thank you very much for your attention. Right, so okay, so the second question we had was around Consumer New Zealand's produced a good assessment of how difficult or easy these policies are for various loyalty programs, what data they collect and use. That's a really good example. Emma, if we could perhaps share that link, I support that. And there's been some other examples too where, particularly in the context of insurance contracts, they've tried to rewrite, I think it's the Right Mark project, to rewrite some of these contracts in a more accessible way. But it's a good point. And there are some interesting other projects which are trying to create graphical representations, or there's the Pribot chatbot that lets you ask questions, specific questions. And thanks very much for Emma producing that link. Okay, there's a oh, I'm sorry to hear this, that someone was impacted by the MyHeritage breach. And oh, okay. So a question for me is whether I'd recommend any one company over another at the moment. At the moment, for the purposes of ancestry, I wouldn't really recommend any particular company over another one. If it's something you really are interested in doing, I would recommend, that this sounds probably horrible, but actually comparing their policies on their websites and seeing if there's anything that you think is problematic about how your data might be used. I don't think any out of 23andMe, Ancestry DNA, MyHeritage, or Family Tree DNA are necessarily better than the others at the moment. They also frame their populations differently, so you can get quite different ethnicity estimate results. So, I mean, it's quite possible for someone to find out that they were donor conceived, or they have a different biological parent through this process, although I would still urge someone to have follow-up testing if they can, because it is possible for samples to get contaminated or mixed up in this scenario. But for things like ethnic heritage, it can really vary. And there's been some bad examples of normally smaller, lesser known companies, but there have been some examples of companies providing human ethnicity estimates on the basis of dog DNA samples, which you shouldn't be doing if you're a good scientist. And so at the moment, unfortunately, I wouldn't recommend any company in particular for this. And I'm sorry not to be able to say anything further on that. Good question here. If companies change their policies and use genetic information for a purpose other than that for which it was collected, surely that would be a breach of Privacy Principle 10 of the Privacy Act. Yes, I agree with that. The problem is that these companies, particularly the largest ones, are multinational big tech corporations that are very hard to sue. And I'm really hoping something good will come out of the class actions that have been filed against 23andMe. But in the past, class actions that were filed against them have not succeeded, basically because they had a compulsory arbitration clause, which is also really problematic. But yes, I think that a lot of the behavior of these companies breaches both the New Zealand Privacy Act and the GDPR. But at the moment, we haven't seen a lot of enforcement action against these companies. Good question. Do the companies actually keep the sample or just the results? It depends on the company, but likely both, depending on their policies. Some of them may now say that they will destroy the sample on request. There's a lot of things they can do with the physical sample, which means that for the most part, generally, a lot of the larger companies, particularly those who want to do medical research, are likely to be storing the sample and the results. Interested in how the Privacy Act, GDPR, and data retention work in the situation of keeping data, or is it covered in the terms and conditions when signing up? So this is the problem. So in some versions of some of these websites, you might have a terms and conditions document. You might have a separate biobanking consent form if you're participating in research, and you might have a privacy policy and several other documents. The really problematic reality, and I've been looking at different versions of these documents over the years, but sometimes they'll say things like, we can share data with affiliates. Now, affiliates would include all the pharmaceutical companies that 23andMe has entered into partnerships with, for instance. And in terms of intellectual property licenses, while it's legitimate that a company may want to protect their IP and things, and the goal for most of these entities is to create products, or often diagnostic products or pharmaceutical products, and other types of acquire other types of patents. But a lot of this does tend to be framed very broadly and includes lots of different entities that might succeed the company or be partnered with the company in some way. And retention, I think, is really problematic because some of the examples I've seen over the years seem to indicate that even where you didn't consent to have your data used in research, the data might still be used for sort of market research and quality checking, which might mean that sometimes it might look like they're not storing data, but they might actually, in fact, be storing data. This is not sounding very positive. I should say I'm not an anti-industry person, but this is an industry that really needs to be a lot better regulated. And the last question, meaning that you give the organization it in perpetuity. Yes, I agree. To a large extent, once it's there, and we can trust businesses to do the right thing. But often, even if we just think about me as an individual, it's any individual here today, it's very hard for any one of us to sue a multinational corporation on our own. And so if you do have privacy concerns or any concerns about what might occur in the future based on the use of your data, it's really better not to engage with it at the moment. I'm hoping things will improve in the future, And with developments in AI that are going to be used in the genomics context, we really do need reform. But yes, I'm sorry not to be more encouraging about engaging with this, but this is something that we do need more education around. People need to be aware of it. I'd really like to see a variety of things happen. So I support regulatory action, but I also support education for the general public and information about what tests are more reliable and what companies are more reliable. At the moment, there's been a lot of problems because there was a privacy best practices document released with several companies supporting it in the last few years, but at least one of those companies had to be removed quite early on because that was family tree DNA because they shared data directly with the FBI without telling consumers initially. So there's been a lot of things that have gone wrong, and unfortunately we're living in this very much data-driven world where anything can be hacked at the moment. So we do need to be cautious. Are there any more questions? Oh, there's a couple more. One more. Okay. Interested in your thoughts on secondary uses of this type of data by law enforcement. Do you think it needs to be explicitly stated by the company or authorized by law? I think both, to be honest. And in the law commission's recommendations, they recommended having warrants used in this context. I think we need legal reform. I do think we need things like mandatory codes of conduct and codes of practice for the industry. But I think it should also be made clear to the consumer. There's a lot of scope, particularly when we think about the nature of these websites. They've often got a lot of social networking and interactive features. It would be possible for a company to make a more interactive privacy policy or online contract to highlight significant things. So bearing stuff like you might find out that your father isn't your father at the bottom of a 15-page long contract is probably not really sufficient notice if we think about it. And having a term that says we can change our terms at any time really challenges the certainty of both the contract itself, but also what privacy practices the company is actually using. Anyone else? Just skip to my last slide, but I'll just wait a moment in case there's any more questions. Thank you so much for attending. I'm delighted that so many people came, actually, but this is a really important area. It's something I care very strongly about, and I've been working on for more than a decade. So if anyone wants to contact me, I'm also interested in collaborative research and also engaging with the public about education around this. So thank you. Any other thoughts? Okay. Thank you for your kind comments, and genuinely happy to be contacted. I think we've got 1 minute left, so I'll just stay online until Emma closes the call. But if you do have any further questions, oh, there's one. The retention one. Did I find any retention clauses? I have had a look at some of these. I'm happy to talk to you after the event about the specifics of that. I think a reasonable retention period, I'm skeptical on what that would be at the moment because it also depends on the person. So for children, I would suggest a period that's much shorter generally. And it's something I think the contracts as a whole really need reform for retention periods to be acceptable or reasonable, in my view. Any other things? Sorry, I missed your question initially. Yes, and yes, you can contact me on Proton Mail. So I think I think we're done. No more questions. But thank you very much, and I hope to see some of you again.